Welcome to The Explainer. Today, we're scrubbing in to perform a bit of a legal autopsy on a truly fascinating piece of history. Picture this, it's 1996. South Africa is a newly minted democracy, and a brand new provincial constitution, one that passed unanimously, by the way, is essentially put on trial. We're going to examine the landmark Constitutional Court judgment that completely dissected the constitution of the province of KwaZulu-Natal. It is just a brilliant case study in what happens when raw political power collides with strict legal boundaries. So let's just dive right in and see how a document celebrated by politicians was systematically taken apart by the judges.
Here's the roadmap for our procedural autopsy today. First up, a constitutional autopsy to set the scene. Then, we'll look at the rules of certification. After that, we're dissecting three fatal flaws: usurping power, the loophole, and suspensive conditions. And finally, we'll hit the final verdict.
All right, part one, a constitutional autopsy. Let's set the scene.
So, to really understand this case, we've got to cast our minds back to 1996. South Africa was operating under an interim constitution at the time. Now, this document actually gave provinces the power to write their very own constitutions, which is pretty huge. But there was a massive catch. They had to be certified by the National Constitutional Court. And man, the timeline here was lightning fast. On March 15, 1996, after tons of lengthy negotiations, the KwaZulu-Natal legislature unanimously adopted its new constitution. Just 10 days later, on the 25th, it gets submitted for that mandatory certification. Fast forward to June 25th through the 27th, arguments are heard in court, and then, boom, on September 6th, the final judgment is handed down. What started as a massive political victory morphed into a totally complex legal showdown in just a matter of months.
You know, the really incredible tension here is that this provincial constitution was actually passed completely unanimously by the KZN politicians. I mean, literally everyone agreed on it. But it was legally doomed from the start. Almost immediately, the African National Congress and the Government of National Unity lodged serious objections. They ended up dragging this document, which had total local political consensus, right into an objective, unyielding legal autopsy.
Moving on to part two, the rules of certification. Let's talk about those legal boundaries.
To figure out exactly why the KZN Constitution failed so spectacularly, we need to know the rules of the game. The Constitutional Court made one thing crystal clear right out of the gate. Provinces are the recipients of power, not the source of it. The court set up this incredibly strict two-step approach for certification. Step 1, they ask, how does the national constitution deal with this specific power? And then step 2, is the provincial provision inconsistent with that? It's a very rigid test. You step even an inch outside those national boundaries, and well, you fail.
The court's whole mindset here was captured absolutely brilliantly in this one defining quote. They said, a province cannot, by means of the bootstraps of its own constitution, confer on its legislature greater powers. Basically, you just can't magically grant yourself more authority than you were originally given. No constitutional bootstrap polling allowed whatsoever. And honestly, this was the exact lens through which the judges viewed the entire document.
Which brings us to part 3. Flaw number 1, usurping power.
So the first major cause of death for this legal document was how KZN repeatedly tried to act like it was its own independent sovereign state. For instance, KZN boldly claimed the power to establish its very own provincial constitutional court, complete with the power to strike down laws. But looking at the reality of the interim constitution, only the National Supreme Court divisions actually had that jurisdiction. KZN just didn't have the authority to go and invent a parallel judicial system out of thin air. It was a direct, pretty blatant usurpation of power.
And you know, the ambition didn't stop at the courts. The KZN Constitution actually went on to declare the region a quote-unquote self-governing province. It even audaciously purported to recognize the national constitution. Think about that for a second. That is a massive hierarchical inversion. It's as if the province was the supreme authority, gracefully allowing the national law to exist in its space. They also tried to lay down rules for things like labor relations and states of emergency, which were exclusively national matters. They were essentially operating under this total and frankly astounding misapprehension that they shared co-supremacy with the national government.
To really hammer this point home, the Constitutional Court relied on this defining statement. They said, unlike their counterparts in the United States of America, the provinces in South Africa are not sovereign states. See, the U.S. federal system was formed by sovereign states deliberately coming together. South Africa's system was the exact opposite. You had a supreme national constitution that created the provinces and then handed down very specific, very limited powers to them.
Okay, moving to part 4. Flaw number 2, the loophole.
Now, the drafters definitely knew they were pushing boundaries here, so they tried to write this clever little escape hatch to bypass the court entirely. They used something called consistency clauses. Basically, this is a legal drafting device stating that if any provision in the provincial constitution turns out to be inconsistent with the national one, well, it just has no force or effect. Essentially, KZN wrote into their law, hey, if anything in this massive document turns out to be illegal, just ignore that part. They were really hoping to immunize themselves from failing the certification process.
But, as you might guess, the court saw right through this trick. They declared that a constitution simply cannot evade the obligatory discipline of certification. Think about it. If they had allowed this loophole, courts would be fighting for decades over which specific parts were actually valid and which weren't. The whole reason certification exists is to offer the public absolute finality and certainty right now, today, not to defer all the legal validity to some hypothetical battle years down the line.
Next up, Part 5. Flaw number 3. Suspensive conditions.
The third and final cause of death in our autopsy involves a really weird mechanism where they attempted to literally play with time. To grasp this, we have to unpack a bit of legal jargon, the concept of abeyance. Abeyance is basically a state of suspension, like temporary non-existence or inactivity. It's a dormant condition that's liable to be revived at any time. The KZN drafters tried to take all these highly controversial powers and just put them into abeyance. They were essentially trying to keep them asleep until political conditions were more favorable for them.
And they went far with this. They suspended entire chapters on legislative and executive powers. They delayed that illegal provincial constitutional court we talked about, saying, oh, it'll only activate when the final national constitution gets written. They even imposed these bizarre 6-month delays on parts of the text, pending potential vetoes by just 40% of their legislature. It was chaos. They were trying to make the supreme law of their province entirely conditional on future, totally uncertain events.
The court's reaction to this was incredibly firm. They labeled the text an inchoate document, which is just a fancy way of saying it was incomplete. The judges made it clear, a constitution cannot be a maybe. The court reasoned that they were legally required to certify a text as an integrated, completed whole. The people of KwaZulu-Natal deserved absolute certainty about their rights and their government structure right then and there. A constitution just cannot be treated like a rough draft, sitting around waiting to see which way the political winds blow in the future.
All right, that brings us to our final section, Part 6, the final verdict.
So with the massive usurpation of powers, those sneaky evasive clauses, and all those chaotic suspensions laid bare, it was finally time for the judges to make their call. But first, we have to ask a really critical question. Can a unanimously passed constitution be saved if it completely avoids the fundamental rules of power? During the hearings, the KZN legislature practically begged the court to consider that every single political party voted for this document. I mean, surely democratic consensus has to count for something, right? Well, the court was unyielding. They ruled that political unanimity absolutely cannot rewrite the strict legal boundaries of national power.
And that led directly to the court's devastating final ruling. They stated, in our opinion, there are fundamental respects in which the provincial constitution is fatally flawed. Honestly, because of the sheer volume of overreaches and loopholes, the Constitutional Court just flatly declined to certify the text. Just like that, a unanimous political victory was struck down, and KZN was forced all the way back to the drawing board.
Which leaves us with this final, somewhat provocative thought to chew on. Is legal certainty the ultimate price for a functioning democracy? As we've seen in this explainer, in the super delicate early days of a new nation, establishing strict, unbending rules about exactly who holds power is sometimes even more important than celebrating regional political consensus. Because without those rigid legal boundaries, the very foundation of the state could just fracture entirely. It's a lot to think about. Thank you so much for joining me for this explainer, and as always, keep questioning the structures that govern us.